Good afternoon, sir. Can you see and hear me?
Yes, thank you.
Thank you. I will carry on. Please, can we bring up page 201 of the witness statement? And the bottom, please, 363. Mr. Aujard, just before the break, you were discussing your paper to the ARC committee. And your statement says, my note of 8 November 2013 was then discussed at a meeting of the ARC on 19th November 2013. And you refer to there have been concerns about a change in policy of prosecutions, raising questions on previous prosecutions and an obvious reluctance to cease prosecutions, as in their view this acted as a deterrent. You say, I do have some very limited recollection of this meeting and of Paula Venables resigning from what I recall Executive Committee's view to have been in the face of ARC's view, saying that the proposal was not that Post Office Limited would never bring prosecutions, but that Post Office Limited would be more circumspect in the cases it chose to take. Could you just summarise what the difference of opinion was between EXCO and Paula Venables?
So my recollection is that the EXCO were in favour of ceasing prosecutions entirely, but when the matter was discussed, when that proposition was discussed at the committee, Paula interjected or made the comment that proposal D, proposition D, to cease everything entirely, should not be taken as what I'd intended it to be, never bring prosecutions, but rather there should be a limited prosecutorial activity, and that Post Office should continue to take some prosecutions.
Did that include prosecutions relying on Horizon data?
I don't believe it was specific at the time.
Did she say what her basis was for that difference?
No, I'm afraid I've got no recollection of that meeting other than the limited recollection of that comment.
Do you know if Paula Venables was aware of the 15th of July 2015 Simon Clarke advice or the issues in it?
No, I'm afraid I don't know.
Following this meeting, did you inform anyone on the board about the Simon Clarke advice of the 15th of July 2013?
No, I'm afraid that I had assumed that this advice had been, or at least the contents of it, had been communicated to the board prior to my arrival.
And is it the same for this Helen Rose report?
Yes, indeed, yes.
Thank you. I want to now look at the review itself. Could we go to POL 406581, please? Back to Brian Altman-Casey's advice, which we went to at the start. Could we turn to page 26, please? Paragraph 71. We see that Brian Altman advised that the proposed start date for the review, the 1st of January 2010, was both logical and practicable approach to take. Do you remember reading that?
I don't have a specific recollection of reading that, but I've reacquainted myself with it as part of this process.
Can we turn to page 42, please? Paragraph 130. So it refers to an earlier telephone conference, but says a question had been floated about the Falkirk issue as one example as potentially bearing on the mediation scheme. The Falkirk event was raised in the Misra case. In the course of Gareth Jenkins' evidence in Misra, Mr Jenkins gave evidence about a Horizon event which had occurred at Calendar Square Post Office in Falkirk in 2005, whereby information recorded on one terminal was not being correctly passed to another within the branch, creating a receipts and payments mismatch. A software fix of the problem was distributed into the system in March 2006 as part of a fairly major functional change, and therefore post-March 2006 the Falkirk defect was no longer an issue. So looking based on this paragraph, can we take the following from it? Firstly, that an event or issue called the Falkirk event arose at the Calendar Square Post Office in 2005.
Correct.
We're not sure when in 2005.
Correct.
Was that correct?
Correct.
Thank you. A software fix was distributed in March 2006.
Correct.
So post-March 2006, it was thought that the Falkirk event couldn't arise. Do you accept there was no indication as to when the bug that refers to the Falkirk event, when that first arose?
Correct.
So assuming favourably that it arose in 2005, it was live between 2005 and March 2006.
Correct.
Why then did the review have a start date of 1st January 2010?
I'm afraid that I can't answer that question. I don't know. It predates my joining the post office. I don't know why that date of 2010 was chosen, other than it probably coincided with the introduction of Horizon Online. But beyond that, I'm afraid I wouldn't know.
But again, this lands on your desk in the first few days. Did you not think it was incumbent to review it and consider whether the advice therein was appropriate?
Yes, I did at the time, and I believe I did review this advice. I also believe that I talked to Cartwright King and others in the office who are aware of historic issues to ascertain from them what, if any, further actions needed to be taken. And I think I said before the break, in none of those discussions was it raised that there were currently live issues or issues that needed to be dealt with. With the benefit of hindsight, I can see that, now you've pointed out that paragraph, that should have been a line of inquiry I could have gone down. But at the time, in those first few days, when I had no formal handover from my predecessor, and was lying very heavily, in fact, very heavily on external advisors and internal members of staff to tell me what was a current and live issue. I'm afraid that wasn't something that was flagged to me.
So we've heard about Cartwright King, they're the external advisors.
Correct.
When you say internal,
Internal. So
who are you referring to?
So that would have been Jarnell Singh as the criminal lawyer. I would have thought this is supposition because I wasn't there obviously prior to my joining, but matters such as these, I would fully have expected him to bring them to my very firm attention very clearly upon joining.
Did you talk to Leslie Sewell in the IT department?
Not immediately in my first short period, no. I think I probably met her by way of introduction in the first few weeks, but I couldn't say exactly when. Did
you discuss with her this Falkirk issue?
I don't believe I did at the time, no.
Why not?
I believe that during the first few meetings, as with any entry to any organisation, they would be focused on understanding what they do, understanding the scope of a person's capability and what their areas of responsibility were, what the current live issues were. For her, I have no recollection during that meeting of this issue being discussed.
Do you have any recollection of it being discussed with her in any future meeting?
I can't think of anything where this issue came up in a discussion with her.
We have here the Falkirk issue, it's known as the Calendar Square book. The second site interim report referred to 2 bugs in Horizon Online. Did you think that Post Office would have had access to documents relevant to any of those 3 bugs?
Turning my mind to that question now, I don't think I turned to my mind to that question at the time, but I would have assumed that the second site report was based on an investigation of matters, and that some of those matters were documented, yes. But I must say I never expressly turned my mind to what informed second site in their investigations.
Do you think it was incumbent on you to turn your mind to that as General Counsel with oversight for a review into past disclosure failings?
I think in the context which it was at the time, and in the way which things were put to me at the time, which were very much along the lines of this isn't there have been issues in the past, they have been dealt with, there are no further matters that you as General Counsel need to be aware of. I don't believe that I would have, in those circumstances, turned my mind, or at least anyone else in my shoes at that stage would have turned their minds to inquire further, having been given those assurances.
So is your evidence to the inquiry that at the time you thought you were satisfied that the only disclosable documents were the second site interim report and the Helen Rose report?
And any other matter which was ascertained as part of the review work that was being undertaken. So, for example, Cartwright King were, to the best of my knowledge, reviewing 300-odd cases. If something came up as part of that process, for example, a matter in one case that wasn't disclosed in another, I would have thought that if there was anything in there that would have come up, I would have been informed of that, yes.
So that had to be flagged to you by Cartwright King?
Cartwright King, I think, as I said before the break, my understanding, which is clearly incorrect, my understanding at the time I joined was historic issues had arisen. Cartwright King had put in place a process to sift all the cases to ensure appropriate disclosure was made, and none of these additional issues were raised to me by them at the time.
Would you accept it as a failing not to have searched for further documents that may have been relevant to those bugs to which Post Office had access?
So I accept that there was a duty on the Post Office as the prosecutor to ensure that all relevant material was disclosed to those that had been convicted. I also accept that as part of that process, it would have fallen within, at that stage, the remit of the legal team. It would have fallen in the remit of the so-called Wednesday morning hub meetings, which were, to the best of my knowledge, being undertaken at that time. And it also would have fallen in the remit of those in the security team who had also had knowledge of these matters. So to answer your question directly, I believe there is a shared responsibility to ensure that historic matters were disclosed. However, I think, as I've said before, my working assumption on joining the Post Office was that appropriate processes had been in place and were now in place to deal with those issues.
When you say it's a shared responsibility, do you take a share of that responsibility?
Yes, indeed, yeah, of course.
And do you accept that you were the person with oversight of the teams you referred to?
Sorry, of?
You were the person with oversight or accountability for the teams you referred to, the security team and the legal team?
I didn't have oversight. I had a reporting line, as I said, from John Scott in the security team. I would have felt that he should have reported to me if there were any issues of this nature. Similarly, Jarnell in the legal team, I felt he should have reported to me if there were issues of this nature that needed to be reporting. In that sense, I did have oversight, yes.
At this time, were you focused on other matters more within your area of expertise, like financial services, rather than this review?
Yes, indeed. I perhaps haven't made it clear, but in upon joining the post office, this was one of a very large number of matters, pressing matters, which needed to be dealt with, and it didn't therefore occupy much of my time for those. Well, it wasn't the main focus of my activities because there are other pressing matters to deal with.
Should it have been the main focus?
It wasn't put to me as such, no. Not at
but
the
with
time.
your review as a legal professional, dealing with a review of past convictions, do you think it should have been your main focus?
I believed at the time I gave it the focus which I thought it needed to do the job properly. And if I failed in that regard, then that is something for which I apologise. But at the time, in the circumstances, I believed I was dealing with matters in an appropriate manner, as informed by the information that I'd received from those that had more background and more detail than I did.
I want to move on. I'm going to go slightly out of chronological order and look at something called Project Zebra. This, for background, was in April, May time 2014, so the mediation scheme was up and running. And I want to start by looking at some advice from Linklaters. It's POL 20107 please. So this was advice, excuse me, from Linklaters to Post Office Limited to assist with legal matters relating to the recoverability or the ability of sub-postmasters to recover in the mediation scheme. Is that correct?
Correct.
Can we turn to page 3, please, paragraph 2.3? At the end it says, we note that there is, so far as we understand it, no objective report which describes and addresses the use and reliability of Horizon. We do think that such a report would be helpful, though there is a decision to be made about how broad and or thorough it needs to be. And that effectively, this is the source of the recommendation to get a report which became known as Project Zebra. Is that right?
Correct.
Could we please turn to page 10? Thank you, and down to paragraph 5.34. So it says, even without the baseline report which Second Sight should have produced, just pausing there, Linklaters would criticise the reports produced by Second Sight, and that's the context of that comment, isn't it?
Yes.
It said, and it suggested there should have been a baseline report on Horizon. It goes on to say, it seems to us generally accepted that there are no systemic weaknesses in the Horizon system.
Mm-hmm.
This much is made plain by, and it lists 3 matters. The second, the first point, we see it says, we understand that a Dr. Gareth Jenkins of Fujitsu provided expert reports for the Post Office in several criminal cases. These reports dealt with the Horizon system. He gave oral evidence in only one case, that of Seema Misra. That case resulted in a conviction. In all of the cases, the fact that he was not required to give oral evidence strongly suggests to us that there was no substantive challenge to his evidence.
Mm-hmm.
Do you think if someone was reading that paragraph, they would take less reassurance from it if they were aware of the matters raised in the Simon Clark advice of the 15th of July, 2013?
Yes, indeed.
That document can come down for the moment, thank you. The advice was subsequently presented to the board, wasn't it? I'm so sorry, that was an imprecise question.
Yes.
The Linklaters advice.
Yes, yes, it was indeed. Yeah.
And you presented it.
Yes, yes, with Krista Band, I think, who attended from Linklaters.
When you presented it to the board, did you say that we have legal advice from Mr. Simon Clark that alleges that Mr. Gareth Jenkins breached his duty as an expert?
I don't believe I did, no.
Do you think you should have done to put some context onto the paragraph we just went to?
I'm not sure that I turned my mind to that at the time. The focus of this report was on other matters.
The board subsequently requested or authorised Project Zebra to go ahead, and that was with Deloitte. You were involved, I believe, in putting together the retainer for Deloitte. Is that correct?
Correct, yes. At the board's instructions and in accordance with a brief that they had set, yes.
Could we please go to POL 20108395? And could we go to page 2, please? Further down the page, please. It's an email from Roderick Williams to Gareth James at Deloitte. So Gareth, as discussed, I should say, sorry, you are in copy. Mm-hmm. It says, Gareth, as discussed earlier today, were you involved in that conversation? Between...
I may or may not have been. I'm afraid I have no recollection of that conversation. If it says
It goes on to say, in order to respond to these allegations, which have been and would in all likelihood continue to be advanced in the courts, Post Office wants to demonstrate that the Horizon system is robust, fit for purpose, and or operates within an appropriate control framework. Is it fair to say that that doesn't read as if Mr. Williams is requesting an independent investigation into into the integrity of Horizon, but more a document to respond to allegations about the Horizon IT system and demonstrate that it is robust?
I can't speak for what was going through Mr. Williams's mind at the time, but I would say it would be standard, and I should also say that at the time, and now, in fact, this doesn't strike me as an unreasonable way to preface a short email to set out the proposition that is to be tested.
Well, let's look at the terms of engagement, please. It's POL 20108462. Thank you. This is dated the 9th of April, so a few days after that email. Presumably there'd been some discussions or correspondence between Deloitte and Post Office regarding the retainer, and this was what was settled on following those discussions. Mm-hmm. Was that yes?
Yes, sorry, yes.
If we could go down, please. It says, under scope and objectives, you want to demonstrate that the Horizon HNGX system is robust and operates with integrity within an appropriate control framework. Goes on in the next paragraph to define part 1 work, saying, Deloitte is to provide, based upon information made available to us by you, an independently produced summary of the assurance and other work undertaken over your current day Horizon HNGX system for presentation to and discussion with the Post Office Limited Board. Go to page 3, there's a bit more substance put on that. See at the bottom, I'm so sorry, page 2. Thank you. A bit further down, please. Thank you. So services, part 1 of our services will provide the following. And then at page 3 at the top, it says review, understand and consolidate the corresponding investigations, assurance activities and remediation actions which you or third parties have undertaken. See Appendix 1 for the source of information. And it goes on to state the focus of the areas. So this was looking at work, assurance work that had already been done. Is that right?
Correct, yes.
It wasn't carrying out independent assurance work in itself. It wasn't a new...
As I understand the Part 1 work, it was a review of the assurance activities that had historically been undertaken with respect to the Horizon Online system.
And at that point, Post Office Limited wasn't aware of any assurance... At that point, had you yourself been briefed on what assurance work was already available to Post Office Limited?
I wouldn't have thought I was briefed on any detail as to the assurance work that was previously been undertaken.
If we could go down, please, on page 3, I want to look at some of the assumptions and limitations. It says you do not require Deloitte to comment on or test the quality of the assurance work performed, nor opine on its adequacy, sufficiency or conclusions, or the integrity of the Horizon HNGX processing environment, nor the legacy Horizon system. Turn to page 4, please. And it says, you agree that other than as set out in the services section above, we will not audit or otherwise test or verify the information given to us in the course of the services. It goes on to say, we will not perform or re-perform any assurance work that has tested and concluded on the design, implementation and operational effectiveness of any internal controls over the Horizon process environment. And then if you could go to page 7. Good assumptions. And if you could go further down the page, please. About midway there. Unless otherwise instructed, the Deloitte staff will have no direct contact with any third parties other than the named Fujitsu contacts that you provide to us. Next but one on, Deloitte will not verify or test any information provided directly by you or indirectly by third parties via you. So it's a paper-based assurance review, yes?
I believe the expression that was used at the time was a desktop-based assurance review, and which I had understood to be, from my IT colleagues, to be standard practice for this type of assurance activity.
It's not testing the adequacy of the assurance work already taken out?
No, it appears from this description to be looking at the universe of assurance activities that were undertaken and providing a desktop commentary as to whether those activities that universe was complete.
And Deloitte would speak to people at Fujitsu and Post Office, but accept what they're saying without challenging the accuracy of it?
I believe that's the nature of the desktop activity, yes.
If you could go to page 1, please. We've got the... to the bottom, please. With the Part 1 work, if you see the penultimate paragraph refers to the Part 2 work, it says, we understand that the input provided by Deloitte will inform your decisions relating to potential areas of additional work that you may choose to commission to respond better to the allegations, and that we may be involved in the delivery of such additional work, Part 2 work, under either a change order or separate engagement. So is it envisaged that once Post Office had reviewed the Part 1 work, it may commission something beyond a desktop review, which Deloitte may carry out, and that was Part 2 work?
I believe that's the case. In practice, it didn't quite work out like that from memory.
in your witness statement, and we can bring this up, please, page 114, paragraph 214. You referred here to the Linklaters Project Zebra work. And you say in the middle, in broad terms, it was directed at trying to establish whether or not Horizon was designed and functioning as intended. Is it fair to say that the Part 1 work wouldn't be able to establish whether it was functioning as intended?
I believe that's correct. Part 1 work, and again, I would have to defer to those with greater IT expertise than I have, was designed to look at the assurance activities that are undertaken with respect to Horizon with a view to informing further work. I also believe that was in pursuance of a sort of board direction given at a board meeting earlier that year.
Please, could we look at poll 406565? These are minutes of a meeting of the Project Sparrow subcommittee on the 9th of April 2014. So the same day, I think, as the engagement terms were signed. Can we look at... Sorry, not signed, sorry, sent, I should say, the same day they were sent. Could we look, please, at page 4? And to the bottom. We see there's an update on Horizon Online, HNGX Horizon Assurance work. And at C it says, although no system could be absolutely bulletproof, no issues had yet been identified through the case as being investigated or any other route that has called into question the integrity of Horizon, nor have any widespread systemic faults been identified since Horizon Online was implemented. These 2 points, along with the Part 1 work, presumably referring to the Deloitte Part 1 work, yes?
Yeah, correct. Yeah.
Depending on the results, should be sufficient to assure Post Office that Horizon is fit for purpose. Who is saying this at the meeting? Can you remember?
My recollection is that the work was commissioned by me in order to ensure legal professional privilege attached to the work product. The content and structure of the work would have been very much informed by the IT team, the CIO. I imagine that's Leslie Sewell. I can't recall the extent to which the finance function was involved in this. After all, Horizon is an online accounting system, essentially. The words here, I think, would have been a combination of inputs from various people, including, very, very, very much including Leslie Sewell in her capacity as CIO.
Why would the Part 1 work be sufficient assurance to assure Post Office that Horizon was fit for purpose?
Sorry, I didn't get...
Sorry, why was if the Part 1 work had come out as Post Office hoped it would do positively, why would that desktop review in itself be sufficient to assure Post Office that Horizon was fit for purpose?
In the event, I think that the Part 1 work was subsequently superseded or augmented by a further piece of work which arose out of that Part 1 work. My understanding is that Part 1 was a scoping exercise in part, as well as an assurance gathering exercise, insurance information gathering exercise. It was as part of the information gathering exercise that it informed what I believe was a subsequent piece of work asked of Deloitte that was more specific and focused on the questions that the board felt it needed to answer.
We'll come to that shortly, but as I understand it, in April, part 2 was never enacted, is that right?
I believe so, yes, that's correct.
And it says here at D, part 2 was not an essential piece of work at this stage.
I believe that's correct, yes.
So why, again I ask, when you said earlier part 1 wouldn't be able to assist with whether Horizon was functioning properly, why was it considered that it was only part 1 work that was essential at this time?
I'm afraid I don't know why that conclusion was drawn. I can't recall why that conclusion was drawn.
Did you not have any doubts yourself
As to
whether part 1 would be enough?
My recollection is that the part 1 work was raised some further questions and that they were addressed in a subsequent piece of work, but the part 1 work on itself only gave the board comfort as regards existing assurance activities that have been undertaken, but no more than that.
So you can't assist further with why it was saying part 2 work wasn't essential at this
No,
time?
I'm afraid it's outside my sphere of expertise.
I want to come back to something you said earlier about this work and your instruction. You referred to it being you instructing Deloitte to maintain legal professional privilege. Why was that seen to be an important matter?
I believe at that time, possibly we're talking April 2014, that by that time the JFSA had made it clear, or at least made it clear to Second Sight, and in turn I think it made it clear to us, that litigation was likely as a consequence of the mediation scheme, and that information was being gathered as part of that scheme for the purposes of pursuing litigation against the Post Office. And I think it was in that context that the decision was made to try to preserve legal professional privilege where appropriate. And it was, I think, on advice, I'm not sure if it was advice from Linklaters or advice from Bond Dickinson, that this was commissioned by me as General Counsel for that purpose, to ensure that there was legal professional privilege.
Okay, two points arising from that. The first is, assuming, in a hypothetical at that point, when you're the Deloitte had been instructed by you to maintain professional privilege, if the report had come back very negatively and it was adverse to Post Office, can we infer that the intention was to rely on legal professional privilege to try to stop that being disclosed outside of the Post Office?
I don't know if we can infer that at all. It would depend entirely on the outcome. My view would be that my recollection of the Post Office at the time is as follows: if it was of a matter that pertained solely to civil litigation, then consideration would have to be given as to how that would be dealt with. Clearly, there were mediation cases going on at that point. This is conjecture. My view would be it would be disclosed as part of those mediation cases. If it pertained to matters which had a criminal disclosure component to them, it would be disclosed under the normal rules relating to disclosure of material relating to past criminal convictions. But I'm afraid that they're both conjecture, because hypothesising as to what may have happened in a certain circumstance.
So why was privilege being maintained then?
I think out of an abundance of caution.
Caution for what? Caution
to ensure that if the report arose in such a manner as to that where privilege could be asserted, that opportunity wasn't foregone.
You said it was obtained on advice. Just so I can be clear, that's advice either from Linklaters or from Womblebon Dickinson. Is that your recollection?
I would have thought so. I would have thought so, but again, I have no specific recollection of where the advice came from.
Please, could we look at poll 30's21524? It's a meeting of the Post Office Board. If we can go down to the attendance list, please. We see that you are in attendance for items 1448 to 49 and 1455. Could we turn to page 6, please? So 1455, we see that you're introduced there with Gareth James, who was a partner at Deloitte responsible for the work. It refers to a draft report, which we don't need to go to at this stage. I want to look at the minutes at D&E, please. It says that Gareth James reported that all the work to date showed that the system has strong areas of control and that its testing and implementation were in line with best practice. Work was still needed to assure the controls and access at the Finance Service Centre. Do you know what that refers to, the Finance Service Centre?
I believe that was part of the accounting function.
With the next paragraph, Chris Aujard explained that several of the sub-postmasters who were challenging Horizon had made allegations about phantom transactions which were non-traceable. Assurance from Deloitte about the integrity of the system record logs would be very valuable. Phantom transactions is used in numerous ways. Can you explain how you were using the term phantom transactions here?
I don't believe I have any real recollection of what was meant by phantom transactions in this context, other than the description that was given, which was there were non-traceable transactions that sub-postmasters were concerned were appearing in their accounts.
So would this include the allegation that a third party such as Fujitsu could add, edit or delete transactions in branch accounts, what we can now call remote access?
Yes, I would say that.
So remote access at this point is firmly on the board's mind and on your mind, it seems.
Yes, I'd say that's true.
Could we look, please, at poll 40's6566, please? This is a meeting on the 30th of April of the Project Sparrow subcommittee of the board. You're there being present. Could we turn to page 2, please? B, says Chris Aujard reported on a conversation that he had with Gareth James, Deloitte partner, after the board meeting, in which he explained the visibility of transaction corrections. So that's after the meeting we've just been to, the minutes of which we've just been to, correct?
Correct.
So you had this conversation with him. Chris Aujard further explained that Gareth James thought the fact that transaction corrections were visible would enable his assurance work to be completed more quickly. Chris Aujard was asked to liaise with Deloitte to ascertain what level of assurance could be achieved in 1, 2 or 3 weeks and at what cost. So again, you'd had a discussion with Gareth James after the meeting and you were reporting on it to this meeting. Why was remote access an issue such as transaction corrections at the front of your mind at this time?
I would imagine, but it's only it's conjecture, that following the board meeting there was a discussion regarding the so-called phantom transactions, discussion or email exchange, I don't know which, and that as part of that discussion, and somewhere in here it references the fact that those transactions were visible, Gareth James gave assurance that it could be reviewed and a view formed on it relatively quickly.
But you're aware that transaction corrections are a particular type of insertion into branch accounts which a sub-postmaster would see. You were aware of that at the time, presumably?
I believe the expression transaction corrections covers a multitude of different transactions being entered into the sub-postmaster system. I don't know whether this refers solely to transaction corrections that were, quotes, phantom corrections, or other transaction corrections, which I believe are entirely visible and are seen by the sub-postmaster.
I'm not going to cover that point now because we'll come some documents which I think shed some light on it shortly. But before we get to that one, can I go to Poll 3029728, please? If we could go to page 3, please. It's an email from Roderick Williams on the 20th of May 2014 to Gareth James and Mark Westbrook, both of Deloitte, copied to you. And he asked for an update on something Mr. James had identified, saying you identified an example where a horizon control was not implemented as understood, namely that the audit store Centira box is configured only to basic settings, not the more secure CE plus setting, as we seemingly understood. Do you have any recollection of this issue now?
I have some recollection of this issue, but not a detailed recollection of the issue.
Can you remember why Roderick Williams was raising this as a particular point of concern at this time?
So the timing of this is 20 May, prior to the receipt of the
72-page report.
Yeah. So I imagine that this is being sent in order to understand and inform the detail of that report. But that's a slightly reconstructed memory, I'm afraid.
So these are matters that are going through your mind, or you think reconstructed, going through your mind and Roderick Williams' mind, which you want to be more information on now, and presumably these are matters that you would then look out for in the future report.
Yes, indeed, yes.
Could we turn to page 2, please, and go down? I don't need to... You've seen this email I sent to you. I don't need to take you through all of it. It's a description of what the issue was. In the middle, it says there remains a small risk that can only really be discounted by detailed testing, that someone with the requisite access rights to the digital keys used in the sealing process and admin access on the audit store could theoretically delete an audit store record, recreate the transactional data that was originally within that audit store file to suit whatever purpose they might have, seal it using the correct key to generate a valid seal value, reinsert it into the database. What were your views on that when you saw this? Can you recall?
I think my view was informed by the last or penultimate paragraph, which raises a question about who has the requisite access rights and is key management able to exploit this, which to my mind was an issue that needed therefore to be investigated further by Deloitte before they could opine on it.
So, as a principle, is it fair to say it's a worrying proposition that this type of access and edit rights is possible, but you thought there's a sort of in practice thing to investigate of whether or not it could actually be used in practice?
I think that's probably a fair summary of my state of mind at the time.
We referred to a 72-page report. I want to turn to that now. It's Poll 3028062. So this is the draft dated 23rd of May 2014. A report of some significance, would you agree?
Yes, indeed.
So presumably you read it carefully.
On this report in particular, I think that the concern I had at the time was to answer the board's request for a readily digestible, simple report that they could read. I think that when this was received, it was very apparent from its size that it wasn't such a report. It was detailed and technical. My recollection is that Rod reviewed that report. I discussed it with Linklaters, and that we agreed that this was not the type of report that could go to the board. And as a consequence of that, we asked Deloitte to do a further board briefing summary. In light of that activity, I'm not sure that I could say now that I read the report in its entirety. I think what I could say is I reviewed the report, certainly the front end of the report, to see whether a board would find that acceptable.
Two separate things there really are there. One is this is a detailed report and it may contain information that's very important to the business on a technical level.
Correct.
On a separate point, there's an issue of presentation as to whether that's in a form to be presented to the board.
Correct.
The fact this is very technical and detailed shouldn't stop the business or someone in the business from reviewing it in detail.
Indeed, and I believe that with this report in particular, it was reviewed by numerous people in the business a short time after its receipt, though I couldn't say exactly when.
Can we look at page 56, please? This is an thank you. It's Appendix 3, Inventory of Documentation Reviewed. And we see we have Horizon Core Audit PowerPoint. Further down, 6 and 7, Report on Local Suspense, brackets 14, branch issue. Report on Receipts Payments, brackets 62, branch issue. Did anyone in the legal department go through this list to determine whether these are documents that should be disclosed pursuant to the Post Office's post-conviction duty of disclosure?
I'm not sure that they did. I believe, as I said, Rod Williams, who had carriage of sort of the detail of this report, did review this report. I'm not sure that as a consequence of that, he or anybody indeed reviewing it would have picked up on items 1, 6 and 7 to delve further into whether or not they related to matters that concerned disclosure of in relation to past convictions. So the answer is I just don't know, but I don't believe so.
Should someone have reviewed these documents to determine whether they should have been disclosed?
So at the time that the report was properly considered, which I believe was a number of days or weeks later, Yes, I agree that someone should look through this report and ask the question, is there does this trigger any duties of disclosure? I can't at the moment for sure say that that happened. I think I say in my witness statement that I did. I'm not sure whether I took steps to disclose this report to Cartwright King, which would have obviously been the most appropriate next step in these circumstances. If I haven't, that's a matter of absolute deep regret, because it's something that, had I known what I now know about the system and had I the technical expertise to understand these points, I believe that is something that should have happened.
So your evidence is you can't remember if it was given to Cartwright King, but that's how, in terms of how the review works, how you would have gone about the disclosure review, by providing the report to Cartwright King for them to then provide advice.
Yes, indeed, yeah, and to give, or at least to give, if they didn't provide advice, at least to give guidance as to what the next step should be.
Could we turn, please, to page 60? It says here, with the prior permission of Post Office Limited, the following individuals were interviewed or consulted during the course of our review. And we see towards the, or 2/3 of the way down, Gareth Jenkins is there. Are you aware if Deloitte had been informed of the contents of Simon Clark's advice of 15th July 2013?
No, I'm not aware of whether they had or they hadn't, but I believe that they would have been well aware of the fact that he was tainted as a witness for the advice he'd given or evidence he'd given in a number of cases.
And why do you have that belief?
Because at the time within the Post Office that was very much common knowledge. They had been briefed by Rod as part of their onboarding process, and I would have been very surprised if, you know, a salient fact like that hadn't been disclosed to them. But I have no independent, sorry, I should make it clear, I have no independent recollection or evidence that that happened.
Thank you. Can we look, please, at page 30? And if we could go to the bottom of that page, please. So these are some findings. We see 4, system usage. Mm-hmm. There's partial documentation on the right. And under audit store, it says we observe the following. It is not clear from the documentation we've been provided whether Post Office Limited has agreed that the current capturing of certain key system events is complete and appropriate for potential governance and investigation needs. Would you have read this part of the report at the time?
I'm not entirely sure that I would have read this report at that time. I think it's highly likely that I read the report at a later date in full when it was considered by a wider audience internally.
When do you think that would have been?
I believe there was some meetings held at the beginning of June, but I'm afraid I can't give the exact dates to consider this. Certainly it's referred to...
Risk and Compliance Committee meeting.
Risk and Compliance.
We'll come to that in due course. So you think that might have been later on?
I think that was later on, yeah.
So we don't have to come back to it. What was your understanding here of potential governance and investigation needs? What investigation needs were being referred to?
I'm not sure, I'm afraid. Investigation needs. It could refer to a number of matters. It could refer to the criminal investigations, or it could refer to investigations necessary to satisfy the finance function that certain things were operating in the right way. I'm afraid I don't know.
So we have not identified controls which formally report, review and consider the impact and resolution of any exceptions identified during the audit store extraction process, nor reconcile the data from other reporting systems in the business to those data sets contained within the audit store. What did that mean to you?
I believe, as in the nature of these reports, what it meant was exactly the words used, that they have not identified controls. They're not saying there are no controls, nor do I read that to say that there are. Sorry, I finished, yes.
Sorry. Data in the audit store is quite important for Post Office Limited, isn't it?
Correct.
And so not being able to identify controls that review, report and consider the impact of exceptions identified during extraction of that data is quite significant, isn't it?
Yes, significant. However, this is on page 30 of a very long report, and I believe it talks to a headline comment in the summary section, which indicates that things are working as they should. So, to my mind, having reread this report recently, this seems to be identified as a relatively low-level issue that departs from a high-level, as an exception to a high-level assurance that they've given. Having said that, that doesn't in any way detract from the importance of it. It's just somewhat surprising it appears on page 30 of a document where clearly it is of some significance.
Yes, I mean, reading that, do you accept that once you read that, the significance is clear? Once
that is read, it would put, and I think it did put people on inquiry as to what further steps or actions need to be taken.
And did you just say further steps need to be taken?
Yes, indeed, yeah. What other steps? It puts people, I read that to say what, this implies that further actions of some sort need to be taken, either to receive comfort that there are such controls, or to satisfy themselves, or to undertake a further report or some such thing.
Over the page, please. F, I don't need to cover it again, but it's effectively this Centera EMC point, which we referred to in the email before. So this is something you were presumably looking out for, given you'd had an email on it.
At a subsequent time, as I said, I don't believe when this report was received on the 23rd, 24th, whenever it was of May, that I would have gone into that level of detail at that stage. It would be also something that I would have relied very heavily upon my IT colleagues to tell me what the significance of this is, as it appears to be drafted in such a way to say, if A and B, then C, and I'm not sure what the references are in there to the various technical boxes, etc.
Well, do you think it's, as a non-technical person, you can read from this that what they're saying is that it's possible for someone to change the data in the audit store?
Actually, if you give me a moment, I'll read it now.
Please
do.
That's
okay. Yeah. What I read that to say is, if there are no alternative controls, and if management is not adequately segregated, then, and I'm not sure of the technical description of these solutions, the seals would potentially allow privileged users at Fujitsu to delete sealed files. So I read that to say, if two things occur, then sealed files can be deleted. Sorry, but that's my reading it now, rather
and
than
replaced
than
with a fake file in an undetectable manner.
Correct.
And so, again, is this something being raised as a possibility? Further work needs to be done to see if it does occur in practice.
Yes, indeed. Yeah.
And if we can look at branch database at G, please. We see a method for posting balancing transactions was observed from technical documentation, which allows for posting of additional transactions centrally without the requirement for these transactions to be accepted by sub-postmasters, as transaction acknowledgements and transaction corrections require. So we earlier discussed transaction corrections. This is now talking about balancing transactions. Whilst an audit trail is asserted to be in place over these functions, evidence of testing of these features is not available. Presumably that was of some significance. You would have seen that to be of some significance.
I would have thought so, yes.
The third bullet point, balancing transactions, transaction acknowledgements and transaction corrections. We did not identify controls to routinely monitor all centrally initiated transactions to verify that they are all initiated and actioned through known and governed processes, or controls to reconcile and check data sources which underpin current period transactional reporting for sub-postmasters to the audit store record of such activity. So again, with balancing transactions, is this another area of work highlighted that requires further investigation?
Indeed.
And that was the point you entered the contract, that was what was envisaged to be the Part 2 work. Potentially, if Post Office chose to do that work.
Potentially. I'm not entirely sure what would have been covered by the Part 2 work, but potentially, yes.
Well, it was up to Post Office to determine what was covered by Part 2, wasn't it?
Yes, indeed, yeah.
Now, I don't need to go to, there's a lot of correspondence between this report and the June board update. Let's go just to the update. It's POL 3028069. So this is a shorter document, 4th of June 2014, which was prepared for the board. Mm-hmm. My understanding of your evidence is this was sent by email to the board.
Yes, that's what the document shows.
And it's a much shorter document. If we could please turn to page 7. I should have asked here now, but would you have read this in detail before sending it on?
Yes, I would have done, yes.
So, page 7, matter 3, baskets of transactions recorded to the audit store are completed and digitally sealed to protect their integrity and make it evident if they've been tampered with. And the third bullet point, towards the end, says the configuration of the physical hardware does, however, permit administrators to delete from the audit store during the 7-year period, which was a matter found to be possible and contrary to Post Office Limited's understanding of this physical protection feature. This could allow suitably authorised privileged staff in Fujitsu to delete a sealed set of baskets and replace them with properly sealed baskets, although they would have to fake the digital signatures. It goes on to say, we have not identified any documented controls designed to prevent a person with authorised privilege access from deleting a digitally sealed group of data and replacing it with a fake group within the audit store. It goes on. So that's the Centira EMC issue, is it?
Yes, indeed, yeah. Well,
Fair to say that you described the last port as technical. This was put in terms that it was capable and clear for you and the board to understand.
Yes, that's correct.
Please, could we turn to page 8? And down to balancing transaction, please. This is an emergency process accessible only to restricted individuals in Fujitsu, which can create transactions directly in branched ledgers. This process creates an identifiable transaction in the ledger, verbally asserted by Post Office Limited staff to be visible to sub-postmasters in their branch reporting tool, but does not require positive acceptance or approval by the sub-postmaster. The use of the process is a full audit trail monitored by Fujitsu. It's asserted by them that the process has only been used once, in 2010, between 2008 and the time of their assertion in this area. As our work did not involve testing, we cannot comment on the circumstances of this event. And then over the page, please. All processes, with the exception of balancing transactions, operate on the principle of full sub-postmaster disclosure and acceptance. At the bottom, sub-postmasters have access to view all transactional records underpinning their current accounting period ledgers. This information is used to support their daily branch cash declarations of reconciliation, their weekly balance of cash and stock, and reconciliation, and their monthly trading period rollover activities. Again, this is written in clear language as to what balancing transactions are, yes?
Correct.
From this, could you have any assurance that a sub-postmaster would be able to identify when a balancing transaction had been performed by Fujitsu? Namely, that it was visible to the sub-postmaster that the transaction was visible, and that it was visible that it was performed by Fujitsu.
My recollection, but I'm not sure that it's in these words, is that the sub-postmasters can view all transactions entered, whether created or accepted by them or not. So on the first part of your point, which is to do with visibility, my understanding is that it would be visible. On the second part, to do with acceptance, I believe that makes it clear that a transaction such as this exceptional transaction, would not need to be accepted by the sub-postmaster.
I asked a slightly different question. The transaction may be visible to the sub-postmaster. My question is, could you get assurance that the sub-postmaster could tell that the transaction had been inserted by Fujitsu rather than in branch?
Did I get assurance that could be inserted by Fujitsu? No, that this doesn't make it clear up one way or the other.
So that might be a good time to have the afternoon break.
Yes, that's fine. How are we doing generally, Mr. Stevens?
We'll be okay, I'll say, sir.
But that's yes, I won't make a comment.
Yes, there are questions from core participants, and I'll build in time for them. I've got a bit to finish on this topic and another one, but we should be finishing today. So
Good.
I think it's the transcriber said 1 15-minute break it works for her rather than 2 10-minute breaks, given we're having a longer afternoon.
All right, then let's do that. So we're going to resume at 3:10.
Yes, sir. Thank you.
And then we'll proceed accordingly. Thanks.
Thank you, sir. Sir, can you see and hear us?
Yes, thank you. Yeah.
Thank you. I'll carry on. Please, can we go to poll 30297733? So if we go, actually we should say the context. The top email is a forwarding email from Alwyn Lyons to Roderick Williams, saying, sorry, should have CC'd you in as you did all the work. If we can carry on down to the body of the email, please. Thank you. It's from Alwyn Lyons to, if we could just look at the distribution list. Thank you. Those are members of the board of Post Office Limited at the time. Is that right?
I believe so, yes.
It says, please find below a message from Chris Aujard and Leslie Sewell, and attach the Deloitte briefing. Would that have been the board briefing which we just referred to?
I would have thought so, given the date.
Excuse me. If we look further down, please. It says that a board briefing is attached, and then over the page, in the briefing, Deloitte expressly identify a number of limitations and assumptions which underpin their findings. The briefing must be read in this context. That said, its key findings are, and then if we could just show the key findings on the screen, if you could just review them and let me know when you've reviewed them.
Yes, indeed.
Do you think that's a fair and accurate representation of what is in the board briefing?
On reflection, I think this is far too abridged. I think that there are, as we've discussed, issues within the board briefing pack that would or could have been brought out more clearly in this note. The context, I suppose, is there was enormous pressure to get something out very quickly. And in those circumstances, the note, which I believe was prepared by Rod at either my initiation or Leslie's initiation, did not bring out fully those concerns. I suppose the context again is that the board briefing nonetheless was meant to be read by the board. It was a very, very intensive exercise to reduce what was a very long document to a very short document.
We saw in minutes before that the board and certainly subcommittee, Sparrow subcommittee, was concerned with remote access. In that context, can you explain why the issues on remote access that we referred to weren't included in this, or is it simply a matter of time, you say?
I'm afraid I can't, and I believe it was simply a matter of time. This process towards the very end, if I recall, was absolutely racing against the clock to get something out, and also from recollection I was under intense pressure from Paula in particular to get something to the board, so to that extent, and if it's an oversight with hindsight, I regret that this was not as full a briefing as it should have been.
When you had more time, did you provide a fuller update to the board?
I have no documents that show what happened after that briefing was sent and the board meeting. I do know, however, that there was detailed management discussion internally as to the actions that should be taken on the back of that board briefing and on the longer Deloitte report.
We'll come to that in a moment. Can I ask, do you recall, you don't have documents?
I don't have any
Can you
documents,
recall
yeah.
discussing the board briefing with any board members after sending it?
I don't have any recollection. I think it highly likely that I discussed it with Paula and Alice, but sorry, that's Paula Venables and Alice Perkins, but I'm afraid I have no recollection.
You say you think it's highly likely you discussed with Paula Venables and Alice Perkins.
Yeah,
Is that
more highly Paula, less highly Alice? Yes.
But is that a positive recollection or?
No, I'm afraid it's not a positive recollection. No.
Can we please turn to Poll 3031410? This is one of two similar reports on Project Zebra, which I don't think is a material difference between which you identified in your statement, so I'm just going to this one. Do you remember who was responsible for drafting this report?
I believe, but can't be sure, it would have been done by David Mason, who was the head of operational risk, or head of risk, I think, within the post office. I would have thought that it was dealt with, it had input from a wide range of people who I believe are identified on the next page.
It's your name on the end,
Correct.
so you accept
Yeah,
it's
correct.
your
Yes, correct.
responsibility. Sorry, just to make sure that's been put to you, it's your responsibility for this report.
Yes, the process within POL was that all documents submitted to committees had to go in the name of an EXCO member. As Dave Mason reported to me, it would have gone in my name, and I would have reviewed its contents, I believe, at the time, and received comfort from him that it was appropriate and accurate.
Could we look at page 3, please? And if we go down to the bottom. I understand this report was submitted to the Risk and Compliance Committee on the 21st of July 2014. Is that right?
I don't have the date, I don't believe, from the that could be right from the metadata, but I don't have the exact date.
But do you accept it was discussed at the Risk and Compliance
It was discussed, correct, yes.
Do you remember who was in attendance at the Risk and Compliance Committee who would have discussed it?
No, I'm afraid I don't.
We see A1, summary of recommendation, perform a detailed review of balancing transactions and transactions use and controls. Yes. So that was to look at remote access effectively.
Correct. That would mean
and the business view was that should be carried out.
Yes.
What was done?
I'm afraid I don't know. That would have been taken forward by the appropriate internal subject matter experts. And I would have thought, but don't know, that would be the IT function, potentially also the finance function. But I'm afraid I have no details, so I don't know the answer to that question.
This was in the middle of the mediation scheme, wasn't it?
Indeed.
And remote access was an issue being dealt with.
Yeah.
So was it not something you needed to keep on top of?
I would have thought that the mediation scheme, this is a report in draft that's being considered by management. I would have thought it would be appropriate for management to conduct its review and for the output of that review to be disclosed to the mediation scheme. It's very common, I think, in large companies to receive reports and then undertake an internal assessment of that report and come up with management actions or clarify with the author of that report what the issues are, and then, once that's been done, to communicate that externally. And I would have thought that would have been the approach adopted here.
But the remote access, would you accept, is both relevant, we said, to the mediation scheme, but also to potentially to past criminal conviction?
Correct.
Was it not something you felt you should, because it was relevant to those areas for you, it was something you needed to stay up to date with and ensure that this recommendation was being fulfilled or
yes,
taken
yes,
forward?
indeed. No, and I believe, I have no papers to show what happened in terms of activities that followed this meeting. I would have thought in the ordinary course of events I would have been brought up to date as to what assurance activities have been undertaken internally and what activities were undertaken for the organisation to satisfy itself that Deloitte's findings were correct.
And to the best of your recollection, can you recollect anything?
I'm afraid I have no recollection. I have no papers that have triggered any. I have no papers that deal with the period immediately after it going to this committee. Thereafter, actually, it's the papers I've been provided with stop literally at this point.
If we look at this analytical testing of historic transactions, and then at page 5, that's defined. Refers to the audit store documentation asserting that the system holds 7 years of branch transactions and system event activities. In addition, assertions over data integrity, record and field structure and key controls such as JSN sequencing not validated by parties outside of Fujitsu. It refers to techniques that could allow Paul to conduct detailed risk analytics of audit store data. Back to page 3. The business view was not to go ahead with that. It was considered to be a large exercise for which the benefit is questionable. Can you recall why that was?
I'm afraid I can't, and I believe that that would have been a business view very much informed by IT and finance as to what was practicable or indeed possible at the time. But I'm afraid I have no recollection of their reasoning or the discussions that took place in that regard.
Thank you. I want to move on to a different topic, and it's the mediation scheme. I'm going to jump about a bit in the chronology. I want to start, please, in your witness statement, if we can, page 75, paragraph 137. You refer to a series of delays, which we'll come to, which was a cause of great frustration to all those involved. Because of these difficulties, an issue arose as to whether Post Office Limited should explore options for ensuring that the working group was able to do its job more effectively, whilst at the same time ensuring that the right balance was struck between the cost of running the scheme and making sure those cases which had a realistic prospect of being successfully mediated were put through to mediation. You're referring there, are you, to various discussions in Post Office to modify the scheme once it was in action? If we could go to page 74, please. And if you could just put the table into view. In this table, what you're doing is, at various dates, showing Post Office Limited reports that it had conducted and sent to Second Sight, and the process was Second Sight would then review those and produce its report in response, in broad terms, yes?
Yes.
And this table, you're saying, shows in the middle, well, the left-hand column, under number of Post Office Limited reports, how many were sent by Post Office, and the response on the right. Mm-hmm. And we see by the 27th of March 2014, you say that 6 had been sent since the last working group, so at least 10. Mm-hmm. And there'd been no reports in response. Is that right?
Yes, that's correct. I should give a slight health warning on this table. It was difficult to put together because of the way the minutes work, so wasn't always clear to me when I did this table exactly how many were outstanding at any given date. But it's broadly correct, yes.
Well, let's have a look at the minutes on the 27th of March. If you can go to poll 30-26644, please. Now, what happens with some of these working group minutes is we have here that the attendance list and the fact that it was a meeting of the working group, and it's only over the page that we get the date of the meeting. So if we could go to page 2, please. We see it's the 27th of March, so the working group minute you're referring to, where you said there were 6 sent since the last working group meeting. Could we look down to number 4, please? Thank you. We see there it says cases passed to Second Sight by Post Office, and there are 6 listed there. Are those the cases to which you were referring?
I believe so, but yes, I believe so. I believe that's correct.
on 5 of those, it says to be uploaded to Huddle by close of business 28th March.
Yeah, that's correct, yes.
Huddle was the document system which Post Office used to send its reports to Second Sight. Is that right?
Yes, yes.
So is it actually the case that by this meeting, since the last, only one had been uploaded to Huddle for Second Sight to review?
I think that's correct, yes. And as I said, when doing the table, it was a bit difficult to figure out exactly what happened on what date. But the date of this meeting, I believe, was the 27th of March.
27th of March,
Yeah,
so it would be uploaded.
That's right.
There.
So I'm a day out, I'm afraid.
So if we can go back to your statement, please, at page 74. And by March, should that then be 1 had been sent since the last working group, so at least 5?
Yes, on that date, yes.
And by that point, Second Sight had been asked to revise 2 of their reports. So they produced 2 and been asked to revise them. And at that stage, it was also working on it hadn't produced it, but was also working on the part 1 briefing report as well, a more generic report. Is that right?
Yes, I believe so.
So is it fair to say at this stage, Second Sight weren't significantly behind on report writing?
No, I don't believe that is fair to say. I believe it fair to say that the date is clearly incorrect because, as we saw from the minutes, it clearly indicated that the Huddle was to be uploaded to Huddle. I believe it said the next day, so I'm afraid I don't have the minutes in front of me. So directionally, at the end of March, there was certainly a clear view from recollection within Poll that Second Sight were significantly behind in their review of reports.
Because they had responded on 5 reports. Well, they'd responded on 2 and asked for revisions out of a total of 5.
Mm-hmm. And progress was slow.
Could we please look to poll 20105528? And page 7, please. Oh, sorry. Page 4 first, so we can orientate ourselves. So you see, this is a submission for the Sparrow Subcommittee on the 9th of April.
Mm-hmm.
So shortly after the 27th of March, where we just were. If we go to page 7, please. So broad options for consideration and sets out 5. Number 3 being significantly amend the scheme as published whilst undertaking mitigating activities. Yes?
Sorry, which bullet point are you referring to?
Oh, I'm sorry, I'm looking at my bundle and not the screen. Can we go to page 7, please? Do you see that now, that significantly amend the scheme?
Yes,
published?
indeed.
Could we please turn to page 9? see subject in the middle, subject to a satisfactory outcome from the Deloitte assurance assessment, it is recommended that the subcommittee authorises in principle, and in principle only at this stage, option 3, significant amendment to the scheme as published whilst undertaking mitigating activities. The actions necessary to take forward are set out in Appendix A. Now, can you recall what option 3 entailed? We can go to the appendix if you require.
Yes, please.
Yes, it's page 12, please. See, it says the scheme is closed down as quickly as possible. Goes on to say the working group is disbanded and Second Sight's role is terminated. All work underway to investigate claims by Post Office continues, but use of external advisors is minimised. Is that, presumably that's not referring to Post Office Limited's external advisors?
I'm not sure what that's referring to. All work of external advisors is minimised. I wouldn't know from at today's date what that references.
It says mitigating activities may comprise the production and publication of reports into any improvements identified as a result of the scheme, discussing conclusions with each applicant, offers of payment of inconvenience fees. And at the end it says the working group chairman is retained to provide independent oversight of investigation process. Was this in effect saying that Second Sight's role would be finished, it wouldn't be involved in the investigation, and the investigation would be done in-house by Post Office?
Well, I believe that this is suggesting that at least Second Sight's role be reduced. I'm not sure with the question that you've just asked about their investigatory activities. It was clearly a headline option for further consideration. So some of the detail I would have thought needed to be worked out at a later date.
So where it says in that box, the working group is disbanded and Second Sight's role is terminated.
Yes, sorry. Yes, that's sort of. Sorry, I'm confusing myself. Second Sight's role was terminated as part of the working group. Yes.
So it wouldn't be involved in investigating.
I'm not sure whether when this thing was subsequently worked up, there would have been a further consideration as to what role they had, if any, going forward. But I believe this option was fundamentally one which involved not having Second Sight continuing the activities that they're currently engaged in.
Which was to investigate the...
I think the role of Second Sight, as it finally became to be documented in their engagement letter, was not one of, quotes, investigation. It was to look at the points of difference between the Pol's assessment of a case, the sub-postmaster's assessment of the case, identify the points of difference between the two and investigate those points of difference. I think that's quite different from to my mind anyway, from a broad-based investigation from a zero base of any case. It was quite a focused investigation.
But it's an independent third party who's looking at the parties' positions and investigating the points of dispute between them.
Points of difference, correct.
And this is suggesting that then the Second Side aren't involved.
They don't undertake that activity, that's correct, yes.
And would you accept that that proposal lacks both fairness and transparency?
I believe that should be informed by the context of this paper, which was an options analysis, and it was there to put a whole range of different options on the table for consideration by the committee.
But this option was being proposed as the option to go
And
ahead
that,
with.
I believe, was in response to either a board request or a subcommittee request to have an all options paper prepared.
Well, my question was, does this option lack fairness and transparency?
It does lack fairness as regards, or public perception of fairness as regards those in the scheme. I'm not sure that transparency is an issue that I don't really understand that component of your question, but I would have thought that it
Did you
does.
prepare this document?
No, this document was prepared by a team of people involved in the mediation support group, the team that was responsible for the mediation.
So if you look here, there's 3 at the pros. We see quick and simple, limits operating costs. I don't need to read them all. In the cons, penultimate one is could lead to accusations of a post office whitewash.
Yes.
If we go to the next page, please. This is the option for modifying the scheme to streamline the process, adopting changes to governance. We see at the top that second site to act as an expert advisor to working group. And in the pros, it says fairness and transparency. So is it fair to say that you and others at Post Office were well aware that terminating second site's involvement at this stage would lack fairness and transparency?
At that point in time, which is dated, are we in April? I believe we're in April, are we, with this one? That's correct, yes. Certainly fairness.
That document can come down, thank you. Please could we turn to POL 406571. If we scroll down, please. I said at C, the committee reviewed the state of the mediation scheme and the urgency of any decision if it meant moving away from the current position, option 1. The committee agreed that option 3 would be its preferred option subject to the Minister's support and there being a low probability of a successful application for judicial review. Could you just provide some background there as to what the perceived risk of judicial review was?
Sorry, could you please scroll back to the date of that meeting?
Yes, of course. If you go to the top of the document, please.
Right. So my understanding or recollection is that these are minutes of a meeting which was held to discuss various options relating to the scheme. I'm not sure whether this relates to the previous document that you've just displayed on the screen or whether it relates to a subsequent document, which is a much more detailed document setting out different options. I suspect it's the subsequent document it relates to.
Can you recall at this point what was the view of the Project Sparrow subcommittee? Was it to terminate second site's involvement or to minimise it?
So if I recall, and I'm afraid I don't have the document reference in front of me, there was a document subsequent to the one that you've previously displayed on the screen showing various options for the subcommittee in a more formal sense. I believe that's the one, and I'm afraid I could be wrong because I'm doing this from memory, that talks about some very challenging calls potentially needing to be made. If it relates to that document, that's a more formal document that sets out several different options. It explains that each one is suboptimal and goes on to explain that there are two semi-preferred options. One is to bring it, assert control over the scheme within its terms of reference, and another one is an option to effectively bring the scheme to some sort of conclusion.
Well, let's bring up that document.
If we can, sorry, I may be confusing.
No,
documents.
I'll take you to it. It's POL 3022128.
So to be clear, my recollection is these minutes don't relate to the document that you just showed.
Understand. And if we look at page 3, please. You see, option 1 is continuing with the scheme as currently configured and managed. 2, continuing with the scheme but refine its work within the existing terms of reference. And 3, completing Post Office investigation in each case and moving the governance and management of the scheme in-house, ending Second Sight's engagement and dissolving the work.
Yes, indeed, yeah. That's the document. I think this is a document that makes clear that it's a challenging call and that all options are suboptimal.
So if we could go back, please, to the minutes of the meeting. That's POL 406571. And to the second page, please. It says, subject to further legal advice on risk of judicial review, the chairman would explore with the minister the extent to which she would be prepared to support option 3 and explain the alternative approach of option 2 as a fallback. So at this point, is it Post Office Limited's position that it wanted to terminate Second Sight's involvement?
I think that's overstating what's set out in the minutes. So I'm talking here from only on the basis of what's set out in the minutes, but it seems to me that those minutes are saying there are 2 options. One is dependent on ministerial support, or both of them dependent on ministerial support, but one in particular is dependent on the receipt of JR advice.
But if reading these minutes, if the judicial review advice had come back and said there's low risk of a judicial review if you terminate Second Sight's involvement, would Post Office's position have been that the preferable option would have been to terminate Second Sight's involvement?
I believe that the paper contained further process steps that needed to be taken should that occur. There was, I think, a request for a deeper analysis of the PR implications, which would have been Mark Davies, and there were some other procedural steps in there, which I'm afraid I can't recall. But the subject to those procedural steps, and subject to the minister being supportive, and subject to the risk of judicial review being considered acceptable, and I suppose ultimately subject to the board agreeing this, that was the proposal on the table at that time, yes.
And again, would you accept at this point that decision lacked fairness and transparency by removing Second Sight?
So should that a course of action gone ahead, and should everybody have considered that's right? Yes, I would consider that the certainly the fairness element could be challenged. Definitely could be challenged. It would be perceived, and I think that is stated in the paper itself. This could be perceived to be considered unfair.
And was it the case that Post Office Limited wanted to terminate Second Sight's involvement because it was investigating the points of dispute between it and sub-postmasters?
No, I believe at that stage there were, from recollection, at that stage there were numerous issues on the table with the engagement with Second Sight. So I suppose the first of those issues was that there was no agreed engagement letter with Second Sight, and there was a tension between what was the post office's position and what was explained to me upon joining as being the post office's position, which is that Second Sight were to focus solely on cases within the scheme, and Second Sight's position that their remit extended beyond that. It was colloquially sometimes referred to as the Part 1, Job 1 and Job 2. I think at the stage this paper was written, there was a very strong sense by Second Sight that they had a brief to continue to explore everything, the entirety of matters that were referenced in their first report.
The interim report?
Correct, yes, the interim report, sorry. And that was not, as was explained to me, the Post Office's position. It was explained in very, very clear terms to me that the Post Office saw Second Sight solely, at this point in time anyway, as being responsible for being involved with matters and reviewing cases within the scheme. So I think that's the first point of difference. I think the second point of difference was that there was a strong sense within the Post Office at that point that Second Sight were not providing value for money. And that was a matter which, rightly or wrongly, was seen to be very significant in the board's mind. The third point, I think, is perhaps one around balance or impartiality, or whatever one wants to call it, but let's call it balance. That the strong sense that certainly was imparted to me by Post Office was that Second Sight were not approaching the work that were undertaking in relation to the scheme in a balanced manner, but more in a campaigning manner. Whether that's correct or not, is for others to judge. But that was certainly the sense that was imparted to me.
Was it that Second Sight were disagreeing with what the Post Office said?
I don't believe it was a matter of disagreement. I believe it was more a matter, and I'm sorry, getting my timelines confused, at a later date, certainly informed by the Linklater's advice, that Second Sight were not approaching their conclusions in an evidence-based manner, that they were commenting on matters, A, that were outside of their field of expertise, and B, which were not supported by sufficient evidence. So I think that feeling within the Post Office, but more generally, had emerged by the time of this meeting. So there were, I suppose the point I'm trying to convey in response to your question is that there are a number of separate factors, I'm hypothesising slightly, crossing the minds of the board members that were making these decisions at that meeting.
I just want to pick up on one of those briefly before moving on. And this is the point you referred to as the Job 1.
Yes.
So that's the interim report, and you're saying that Second Sight was suggesting that they needed to continue that work.
Yes, and I believe that was based on a honestly held belief that they were mandated by the MPs to continue with their investigation work. And I think, as I've referenced in my statement, there was a strong concern, A, that work was not documented, and B, the scope of that was not clear. But most importantly, I think, as was conveyed to me by Paula Venables, that was not the agreed position, and it was not the position that she had agreed with now Lord Arbuthnot, James Arbuthnot MP at the time.
Well,
So,
they produced an interim report. Do you think it was fair for them to assume they may go on to produce a final report?
that may have been something within their their contemplation. It may have been within contemplation at the time they did the interim report. That was not something that was conveyed to me as being something that they were doing for that year during 2014. In 2014, their focus was on, and I've given very clear instructions on this, their focus was to be on working on matters relating to the scheme and the scheme only.
Well, let's have a look at that. Poll 3099977, please. It says, at the meeting on 27th November, I will come to show this is a note attributed to you and Belinda Crowe. There's no year on it, but given it's covering costs of Project Sparrow and a note on the second site contract and protection for business, an NDA provision, that's likely to be 27th of November 2013. Would you agree?
Yes, I agree. That looks like 2013.
Can we turn the page, please, page 2, and down to second site? It says the contractual arrangements with second site are set out in the terms of reference for the independent review. Pausing there, that's the review that had been commissioned that led to the interim report.
Correct.
So at this stage, in November 2013, the contractual arrangements with second site are still in accordance with the terms of reference for that interim review.
I believe so, yes.
It says, as the role of second site and the nature of their work in relation to the mediation scheme has now changed, has become more clearly defined, we will in the very near future be putting in place new contractual arrangements. Had anyone said to second site at this point that their the terms of reference that had been assigned to them for the independent review had now come to an end and been superseded by the mediation scheme?
I'm afraid I don't know. Belinda and I were 5 weeks into the job at that point, and I believe that we would have been told at that point that the nature of their work had changed and that they were now to focus on the scheme. That would be consistent with what's been written there.
And who told you that?
It would have been a combination of Paula and or Alice. Sorry, Paula Venables and Alice Perkins.
So in essence, you took it from Paula Venables or Alice or both, that second site's involvement with the original terms of reference, namely looking at whether there are systematic issues, had come to a close. That was
at least either come to a close or had been paused for the duration of the scheme.
That document can come down, thank you. Just one more document on this topic, very quickly, please. It's Poll 3021526. It's a meeting of the board on the 10th of June 2014. If we could go down, please. Oh, sorry, I should say we see you're in attendance as well.
Yes, but by telephone, but looks good.
Yeah. If we go down further, please. So we're back to the options we had before.
Mm-hmm.
Option 1, continuing as is, was untenable.
Mm-hmm.
Option 3, this was the one where second site were to be terminated, I think, or subject to various caveats, you said.
Yes, yeah.
So that was discounted because of the risk of a challenge and possible judicial review. So option 2, amending the scheme, was, I think, if we turn over, the one that the board decided to go ahead with. Based on your recollection of the conversation at that time, if post office, say the post office had received advice that the risk of challenge of a judicial review wasn't material, would the board have gone ahead with option 3?
I think I say in my witness statement, and this is speculation because clearly I don't know the state of the board's mind, that option 3 represented very significant, this is outside my area of competence I should say, very significant PR risks for the post office. I think ultimately, once they had been properly considered, I think the board would have found it very challenging to move down the route of option 3. Not to discount it entirely, but it would have been a very challenging decision for them to make, to move down option 3. But sorry, there's a personal view and it's not based on a fact or any specific information.
That document can come down, thank you. Final topic which I will deal with very briefly, also on the mediation scheme. Please could we bring up POL 20199-361. So this is a draft settlement policy, version 1.4. Was this policy, although it's in draft, was this what was used in practice in the mediation scheme?
I don't know whether this policy was used for a subsequent draft. Certainly the principles upon this policy was based were set prior to my joining the post office. And they were ones based on liability, contractual liability for loss.
Could we please turn to page 16? Sorry. That's it. Thank you. On nature of settlement thresholds, nature of complaint, Horizon inaccurately records data and transactions. It says Second Site's interim report found that there were no systemic errors in Horizon. As such, very clear proof will be required of a technical defect in Horizon, along with evidence that a technical defect caused a quantifiable financial loss in the applicant's branch accounts and had a material adverse effect on the applicant. Why was the threshold set so high, very clear proof required of a technical defect in order for Post Office to make an offer of settlement?
So my recollection is that the principles underlying this were set prior to my arrival at the post office.
But let's pause that. You were the General Counsel overseeing the legal work on the mediation scheme. Mm-hmm. This was a policy over which you had oversight, yes?
And in conjunction with the Chris Day, who was the finance.
Yes, I'm sure other people were, but you had oversight of this.
Yes, yeah.
So you could have changed it if you wanted.
No, I don't believe I could have changed this if I wanted to. This was a policy which was adopted generally by, I think, the ExCo. So this was a matter of suggesting changes that would be adopted elsewhere or approved elsewhere. So perhaps adopted is the wrong word.
Well, help with this, please. The interim report set out preliminary conclusions, didn't it?
Correct.
And it said that the Second Site had found no systemic errors within Horizon, but that it hadn't completed its investigations effectively. You said earlier in your evidence that Post Office's position was that Second Site should now be focusing on matters within the scheme, so the disputes between individual.
Correct, yes.
And Post Office took an active role in trying to stop Second Site from producing a public report akin to a final report of Second Site, of the interim report. Is that fair?
Sorry, I'm not sure.
I'll rephrase that.
Last question.
when you were negotiating or the terms of engagement for Second Sight in the mediation scheme, you were seeking to avoid a public report akin to a final report.
And no, I don't think that's fair at all. For the purposes of the scheme, my very clear directions were to ensure, and this I think was from the board, ensure that there were terms of engagement for Second Sight on the scheme, and also to build in certain confidentiality provisions. And the direction certainly from Alice and Paula was that they should focus on the scheme. I don't think that went to say that they shouldn't do a subsequent report after the scheme had finished, or that a further report shouldn't be produced at some point.
Yes, sorry, but the point being that report would come after.
Yes, indeed.
The
yes.
claims had been
I
resolved.
misunderstood. Sorry. Yes. Yeah.
That point being that after the claims had been resolved, the new report would. Sorry, we'll start that again. The Second Sight would focus on, I think your evidence is, individual applicants in the scheme, and at a later stage may produce a public final report.
Yeah, yes, that was a possibility, and I don't know whether a decision, at what point a decision was made, if indeed one was ever made, as to whether they should produce a final report or not.
So can you explain why the threshold for whether a settlement would be offered in the scheme was based on an interim report which didn't come to final conclusions?
Other than the fact that was the only evidence available at the time that these were prepared, no, I can't. I can't say why it was based on an interim report. As there was no, I suppose the answer is there was no subsequent report to base this on. I perhaps should also say that my understanding of this is it reflected the general policy direction that the settlement sums were never intended to be, sorry, this is not my intention, it's the intention or direction given by others when I joined. Settlement sums were never intended to be large, they're intended to be small sums of money, more of the nature of an apology, something of that nature. So that perhaps policy direction informed the setting of the thresholds.
Well, let's, on that and this will be the final topic for me, can we bring up Poll 00116285, please? We see you send an email to Paula Venables in February, 23rd February 2014, and it's saying you're going to comment below. And if we go down, thank you, we see there's Paula Venables' original email, and I understand your comments are in red. Is that right?
I believe so, yes.
If you could turn the page, please. Go to 3.6. So this is commenting on, I think, paragraph 3.6. It says, potential cost 10 million plus serious. When we went into this, is that the mediation scheme?
Sorry, I'm not with you. Which paragraph?
I'm so sorry. Again, I'm looking, it's the top there, 3.6, potential cost 10 million plus serious. It says, when we went into this, the motivation, brackets Alice and me, was to find out what was really going on to create so much noise and to put in place processes that we felt were closer to the way we wanted Post Office to be run, brackets more supportive going forwards. The system that was in place at the time was when we were a division of Royal Mail and accountable to their legal and security divisions. it goes on to say, we did not intend it to result in major compensation for policies that were followed and applied to thousands of others who did not have problems and which were operating in a different corporate context. We seem to have lost this focus, and I'm looking for advice on how we regain it. So you earlier referred to a message about compensation, I think. Is this the message you were referring to?
I think it's one of a number of messages. This is the only one that's in. There may be more in my bundle, but this is the key one in my bundle. Sorry.
No, please.
I believe that subsequently the figures were extrapolated upwards from £10 million plus to, on one occasion, there was one figure of £50 million. There was an early estimate, or estimate after this, but later than that, it was up to £100 million of compensation. So there were some very, very large numbers, which clearly caused the board, I imagine, a great deal of concern.
Well, what was the message coming from Paul Reynolds and Alice Perkins to you about the level of compensation they envisaged being paid to sub-postmasters at this stage?
It would be small sums of money. It would be less than 3 months of a sub-postmaster's contractual entitlement, though if there were exceptional circumstances that could be increased. At a later date, I believe there were additional heads of compensation added, which included an apology and there was another one which I can't quite remember. So there were small sums of money.
Thank you, sir. That's going to conclude my questions. We have questions from core participants, which hopefully we can hear now. If I just take a look around the room. 4 sets of core participants, sir, wish to ask questions.
Well, I'm dubious about whether we can hear them all. So it would involve each of them being strictly confined to 5 minutes, which my experience tells me is very unlikely. So how are we going to deal with this? My preferred solution, and this is addressing you, Mr. Aujard, we have Miss or Mrs. Van den Bogen scheduled for 2 days, and we may well run up against a problem with time, even with 2 days. So I would not ask you to come back tomorrow, but I would ask you to come back at some convenient time when it's clear that we can fit you in with some other witness. But I don't want to make life too intolerable for you. But how does that sound?
Sir, if you're asking for an honest view, my honest view would be I would rather do as much as I possibly can today, but I appreciate that the inquiries need to come first, so I would accommodate whatever the inquiry wants in this regard.
Well, I've got no doubt. Well, first of all, thank you for your honesty. I've got no doubt that everyone would prefer to get it over with. And I accept that. But I have to balance being fair to you with being fair to those who wish to question you.
Yes.
And also fair to the person transcribing. And lastly, as I've said on a number of occasions, when I start at 9:45 or 10 o'clock, by 4:30, my powers of concentration are waning, to say the least. So I need to balance it all. So what I propose to do, as I say, is not to ask for any more questions, but to find a mutually convenient date when you can be brought back for up to about an hour maximum, when all those who wish to ask you questions will have the opportunity to do so. So thank you for coming today, and I'm sorry it's not over. Because there is some delay probably between when you come back and today, I'm not going to say to you, please don't talk to anyone about your evidence. I haven't embargoed people in your position like that previously, so I'm not going to do it with you. And as I say, I'll see you when we can fit you in conveniently for everyone.
Thank you, sir.
Right, Mr. Stevens. So we start again tomorrow at 10:15 with Mrs. van der Mogen. I'm sorry, I mispronounced her name.
Yes,
That probably demonstrates my powers of concentration are waning.
it's 10:15 tomorrow.
Yeah. See you then.
Thank you.